and welcome to KGS everyone. So we are today going to discuss a very recent and a very important topic which has emerged related to the polity and constitution part of your syllabus. So recently the government has introduced a constitutional amendment bill. The constitutional amendment bill 130th constitutional amendment bill with an objective of doing what? With an objective of amending three important articles: Article 75, Article 164, as well as Article 239AA of the Constitution. Now, Article 75 of the Indian Constitution, as you know, deals with appointment of Prime Minister and the Council of Ministers at the union level. The Article 164 of the Indian Constitution deals with the appointment of the Chief Minister and the Council of Ministers at the state level. And Article 239AA relates to the appointment of the Chief Minister of Delhi as well as the Council of Ministers of Delhi. And what is the purpose of the amendment? The purpose of the amendment, or the objective of the amendment, is to introduce a provision as to what happens or what is the consequence if a minister, whether the state or union minister or the chief minister of the state or the prime minister of the country or the ministers of the union territories, if they are arrested or if they are detained for a specific alleged criminal case where the sentence of the criminal case is more than 5 years. So 5 years or more than that. In that case, if they are arrested for 30 consecutive days, if they are arrested for 30 consecutive days for any offense which is punishable for at least 5 years, so either 5 years or more than 5 years, if they are arrested for that very offense, then on the 31st day, they would be automatically disqualified from their position, which means they are going to lose their office. That means on the 31st day, they are no more going to be the concerned minister, prime minister, or chief minister, as the case may be. They are not likely to remain in that very position. And the most important aspect of this constitutional amendment is that in order to be removed from their positions or for them to lose their positions, they do not need to be convicted of the offense. They do not need to be convicted of that offense, which means even if they are not convicted, that means even right now the trial has not found them, the courts that are there, they have not found them guilty of the offense, but still they would be removed from their very position. Now, if you look at the current constitutional provisions related to disqualification of members of the legislature, the provisions of the Constitution are very clear. The provisions of the Constitution say, and the Representation of People's Act, it says that if there is a member of the legislature who has been found guilty of an offense where they are likely to be sentenced for a period of 2 years or more, then they are disqualified from being the member of the or continuing being the member of the legislature anymore. So the Representation of People's Act makes this provision, which means that currently, that means until unless this constitutional amendment gets passed and then gets implemented, till now the provision is that for you to be disqualified, for anyone to be disqualified as the member of the legislature, and obviously to be disqualified as the chief minister or council of ministers or the prime minister or the council of ministers, in that case you need to be convicted of a criminal offense, and the conviction that is there, it sentences you to at least 2 years of imprisonment. So either 2 years or more than that, at least 2 years. In that case, you get disqualified, not otherwise. Okay. So just a allegation or just the registering of a case against a criminal case against someone does not result into their automatic disqualification. Now the provision says that if someone has been detained or arrested, even for an alleged offense, alleged criminal offense, where if they no, if the offense has at least a minimum of 5 years of imprisonment, then on the 31st day, even if they don't resign for their office, even if they are not removed from their office, but they would automatically lose that very position. This is what the provision says. Okay. Now, when we talk about, see, what are the key provisions here? You can see the Prime Minister, the Union Minister, Chief Minister, State Ministers, if they are arrested or detained for 30 consecutive days for any serious offense under which there is at least 5 years of imprisonment. So this is a very important point. So the offense should be serious. That means the alleged offense should be serious by nature. And secondly, the minimum imprisonment of that very case is at least 5 years. Only in those cases only in those cases they are removed, not otherwise. It's not that for any offense, if the individual is arrested for a consecutive 30 days, they get disqualified. No, only for the serious offense where the minimum punishment is 5 years. Clear? Now, this will do what? This will change Article 75, Article 164 and Article 239AA of the Constitution. To be very specific, it will add Article 75 Clause 5A, Article 164 Clause 4A and Article 239 AA Clause 5A. It would be added to the Constitution, providing for this very provision. Primarily, what has to be understood is that the official will be removed, but reappointment can be done, which means the bill does not bar reappointment. Suppose the individual is arrested for 30 days. On the 31st day, the individual loses office. But maybe if on the 32nd day or any day after that, if the individual is released from detention, released from arrest, in that case, the individual can be reappointed. The individual can be reappointed. So it does not bar reappointment. It only talks about the individual being removed from the position that they hold. Okay. Now, what exactly is the objective? So if you look at the provisions of the bill, so the provisions of the bill is very clear with respect to what it wants to achieve. And what it wants to achieve is that if you look at what the bill says that the elected representatives, they do what? They represent hope and aspirations of the people, and they are expected to rise above political interest and act only in public interest and for the welfare of the people. So if there is an individual who has allegedly performed such a crime, which means that is absolutely in contradiction to them acting in public interest. So that is one objective. Second, character beyond suspicion. That means whenever there is an individual who is in the office of a minister, his character should be beyond suspicion. So the people should believe in the ministers doing the right thing. And thirdly, constitutional morality and good governance, which means if a minister who is facing allegation of a serious crime, according to the bill, that goes against what? Constitutional morality, and it also contradicts the principle of good governance. And this would do what? this would ultimately have a negative impact on the trust of the people. And that is the reason why the bill tries to bring about a provision which would, even for mere suspicion or alleged case being registered and the arrest being made, will result into the disqualification of the individual. Okay, moving on. uh, what is the, I have already discussed this. See, if you look at the current laws, if you look at the current law, so which provision of the in Representation of People's Act deals with disqualification? So now, if you look at the Representation of People's Act of 1951, Section 8 of the Representation of People's Act specifically mentions the reasons or the grounds on which an individual can be disqualified from being a member of legislature. Not only just being disqualified from being a member of legislature, but even being disqualified from contesting elections. What are the grounds? The grounds of, if there is any offense related to elections like bribery, undue influence, or trying to impersonate someone. Thirdly, if there is an offense under a law which goes against the sovereignty, integrity, and security of India, or if there is an individual who is alleged to have performed a heinous crime such as rape, murder, terrorism, dowry, etc., etc. And in this case, if the individual is sentenced, in these cases, in these criminal cases, if the individual is sentenced for an imprisonment of at least 2 years, okay, so they are disqualified. But they are not just disqualified for the term that they serve. So if an individual is serving a term of 2 years, they are disqualified additionally for a 6-year term. So 2 years plus 6 years after their release, which means if someone is serving 5 years plus 6 years, which means in total 11 years. If someone is serving a term of 2 years plus 6 years, which means 8 years. So for the 8-year period, they are disqualified from being a member of legislature. That is what the provision says as of now. Okay. Now, there is one very important judgment related to disqualification here, which is what? Which is the judgment of the Lily Thomas case of 2013. So if you read the Representation of People's Act, Section 8 had a clause called as Section 8 Clause 4, which discriminated between individuals who are already a member of the legislature or an individual who is trying to become a member of the legislature. So if someone is contesting elections to become a member of legislature, or if someone has already become a member of legislature, so there was a discrimination made between the two. And people who were already the member of legislature, they were given some specific rights which would allow them to continue as a member of legislature despite the fact that they have been found guilty of a criminal offense. But this right was not extended to people who were not the member of legislature and wanted to contest elections. So they would be disqualified from contesting elections. But if they have already been elected, then they will continue in office, and finally, till the judgment of the Supreme Court is done, they will continue continue as a member of the legislature. Now, this provision was held to be unconstitutional by the Supreme Court. Section 8 Clause 4 held to be unconstitutional by the Supreme Court on this very ground, that it is a violation of right to equality of the fundamental rights. Okay. Next, if you look at the current process, as I have already told you, Article 75 and Article 164 deals with it. Article 75 as well as Article 164 of the Constitution says that a minister is holding office during the pleasure of the president. If he is a union minister, if he is a state minister, so he holds or she holds office in the pleasure of the governor. Okay, holds office in the pleasure of the governor. Now, if you look at what Representation of People's Act 1951 says, now it says that a legislator, if they have been found guilty of a criminal offense for which they are likely to serve a sentence of 2 years or more than that, then they would be immediately, they would immediately lose their seat, and they would automatically no more become the no more be the minister. Okay, so the Representation of People's Act does not have provision specifically related to ministers. It has provision related to all members of the legislature. Okay, like if you just go back 2 years, you would find that Rahul Gandhi, he was found guilty by the court with respect to no with respect to an law which was the anti-defamation law, and which has no anti-defamation or defamation in India is a criminal offense, and the maximum punishment is 2 years. So he was given a sentence of 2 years. This resulted into him being suspended and him losing his membership. However, later on, because the High Court provided stay to that very judgment, so he continued being a member of the Lok Sabha. Okay. Now, if you look at what is the key difference, the key difference, as we have discussed during the very first slide itself, if you look at the current Representation of People's Act, the current Representation of People's Act would require conviction by a court of law. So until unless an individual is convicted, he is or she is, no, she will continue or he will continue being the member until unless they are convicted. But now what is being proposed by the 130th constitutional amendment, that if there is an individual who has not been convicted but just being detained or arrested for 30 consecutive days, in that case, now what will happen is that now they would automatically lose their office. Clear? So now if you look at implications, so what are the implications? There are both positive and negative implications. Positive implications would be obviously the accountability part. So positive implications ensures that the ministers that are there, they are accountable, they are more accountable, and as we had seen, as the law mentions good governance, constitutional morality to be the reasons. But there is a potential negative use of it is also primarily because there is a potential misuse. Like if you look at certain ministers and certain cases. So recently, one of the most important case that came up was related to the arrest and detention of the Chief Minister of Delhi. So Arvind Kejriwal, he was the Chief Minister of Delhi, and he was arrested in that no in a liquor scam case. Now, when he was arrested in that case, he continued to remain the Chief Minister, and he for the whole period for which he was arrested, he continued as the Chief Minister, and he resigned from his chief ministership only after his release. So the Supreme Court allowed Arvind Kejriwal to campaign during the Lok Sabha elections, and for which he was granted bail, and that was when he resigned from office. Okay. So now this is not the case, and this is likely because that is the case. That is the case. So there is a potential misuse, that if suppose, as we know, there have been number of alleged cases where the CBI, the Enforcement Directorate, they have been alleged that they are bodies which are just the mouthpiece of the union executive, and they do whatever the union executive says. In fact, the Supreme Court has also gone to criticize the CBI, terming it to be a caged parrot who speaks its master's voice. Something like this criticism has been of the CBI. So in such instances, there may be that this provision would be used for political vendetta, and people would be arrested and they would be prosecuted just for political reasons, not necessarily otherwise. Okay. So these are the implications of article, no, the new constitutional amendment which has been proposed, which is the 130th constitutional amendment. Clear? So I have in this video discussed not only the 130th constitutional amendment, but we have also seen what are the disqualification provisions, what are the reasons for proposing this amendment, and what are the problems related to this very amendment. Thank you.